This is Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Ilya Shapiro, Director of Constitutional Studies at the Manhattan Institute. He'll discuss what major Supreme Court cases he is watching this term as the justices return to the bench next week to kick off the 2025-2026 term after their 3-month summer recess. They were busy with emergency orders, and some court watchers are saying this could be the Trump term, since we've seen the Trump administration go to the justices on emergency relief as lower courts are trying to block the president's agenda. Thank you so much, Ilya, for stopping by and talking to me for, I know you're busy ahead of the next week with the Supreme Court kicking off. I mean, there's some major cases just even in the first week. I know there's a transgender rights case. You and I talked last term about that. The issue of treatment for medical transgender youth out of Tennessee. Now I know there's at least two that are going to be before the court this term. I was hoping you could kind of highlight those and then tell me, what are some of the top cases you're watching? Is this actually, some people have said this could be a Trump term because of all the Trump policy agenda items that have come to the emergency docket so far and what we might see the court actually take?
Yeah, this term I think is going to be bigger than last term. And this period right now ahead of First Monday is always like a back to school. Everyone's, all of us court watchers are nervous and looking forward to this fresh start. Although this summer felt different. It felt like the court was never really off with the issuance of all of these orders on the interim relief docket. I guess you could say better than even emergency, because not all these things are emergencies. So we never really got a breather from analyzing what the court was doing. But I break it down not so much into three big cases, but three big buckets. And one is what you mentioned, kind of the sex bucket, with the inverse of that Tennessee case, Scrimeti from last term,
right,
where now you have Colorado banning talk therapy to treat gender dysphoria in a way that doesn't affirm it, that doesn't lead to transition.
The last time the court took up a transgender issue, I guess when they issued Scrimeti, that was states are now allowed to restrict basically medical treatment for transgender youth. Now this is what I think Colorado, you can tell me, I think it's almost 24 other states, right, have similar laws where they restrict a licensed therapist can counsel, I guess, youth that are dealing with, is it LGBTQ issues? Is that what it is?
Yeah, they call it conversion therapy, and they're banning so-called conversion therapy. It's not truly an inverse of Scrimeti, because this is going to be decided on First Amendment grounds, not on equal protection or other substantive rights.
Okay.
And I think it's simply that because you're not just banning talking about gender dysphoria at all, but only one perspective, I think they're going to see this as viewpoint discrimination.
Yeah. I was going to say the Christian counselor, I think that was the argument, right? That she's being restricted on how she can counsel her clients, but then others who might promote gender, transitioning for youth don't have restrictions on what they can say.
Yeah, that's exactly right. I think that's the easiest and narrowest way that they can decide this. It'll be interesting if some state just said, okay, well, if we can't ban this, then we're just going to ban all talk therapy for gender dysphoria. You have to go straight to medical stuff right away, to bizarre stuff.
And then they would probably have to travel to different states depending on where they are. Yeah,
and there's two other cases in this sex or gender bucket involving biological males in women's sports. One out of Idaho, the other one out of West Virginia. One involving high schools, the other involving colleges. But really, it comes down to both Title IX, the federal statute protecting women's equal educational opportunities, including in sports, and the Constitution, the 14th Amendment's Equal Protection Clause. I think the court took up these cases to allow states to have these kinds of restrictions so that only biological females are playing in girls' and women's sports. But this really, I think, will be a follow-on to Scrimeti and some of the discussion among the justices about whether gender identity is a protected category and how to treat it.
Okay, and that's kind of where the equal protection aspect might come in, because I know you mentioned the first case with the counselors, more First Amendment. Is this, I guess, what do we get
That's
more?
right.
Okay.
That's right.
Interesting.
Yeah. The second bucket, like I said, the first bucket is sex. The second bucket is politics. There's three cases, one involving campaign finance, National Republican senatorial Committee versus Federal Election Commission. There's a voting rights case that was held over from last term for re-argument involving redistricting and whether you can make out a claim for vote dilution. That is, not that somebody is being denied the right to vote as an individual, but the way districts are drawn prevents, dilutes the votes of racial minorities. The justices have really struggled with sort of the Goldilocks theory of using race in districting. You have to use it a little bit to allow racial minorities to be able to, quote, elect the candidate of their choice, but you can't use it too much because then it becomes racial discrimination, violating the Equal Protection Clause and the 15th Amendment right to vote. I think here they're just going to throw up their hands and get out of this Goldilocks business of too much, too little race and say, look, if you have direct discrimination based on race and voting, sure, that's a claim, but this line drawing stuff based on politics, we're going to be out of that. And the third political case is called Bost versus Illinois State Board of Elections about federal candidate challenges to state regulations of federal elections, time, place, and manner regulations, which the Constitution does give authority to states to do. But in this case, there's an Illinois law that allows the counting of mailed-in ballots for 2 weeks after Election Day, and whether that violates the congressionally set one election day, one election. And this case came up actually on standing, and I think the justices are going to want to say something about this finally, because there have been these slew of post-election challenges that haven't satisfied anyone. And I should mention that initial case I mentioned, the campaign finance case, is about restriction on coordinating spending on advertising between parties and candidates. Kind of a ridiculous rule, really, that's been obviated by a lot of practical developments, both at the federal and state levels.
On the standing one, so like that, I thought was like when you talk to people about it, especially like non-lawyers, you're like, well, if a federal candidate can't challenge this, election day, like the 14, I think it's Illinois is 14 days after election day for the mail-in ballot coming in. If like a candidate can't challenge it, who could, I guess, is the question on standing, right? And
it's even worse than that. The way that the Seventh Circuit ruled here was that the candidate can't challenge it too early, but then you can't challenge it too late. And also, this particular state representative apparently wins his elections handily. So the rule, however you count the ballots, apparently wouldn't affect his election, and therefore he doesn't have standing because of that. And so, in effect, what the Seventh Circuit was saying is that you can only challenge right after the election in very close cases, which is the worst possible time you would want to have judges trying to figure out these complicated issues.
Right. And we're talking about what cases that they're going to hear. So this is one that I'm going to throw at you that I guess they haven't decided yet if they're going to hear or not. Maybe we might know next week if they make a decision, but it's like October 2nd. And so it's still pending, but there is a case out of Mississippi, right? That did directly deal with, I think Mississippi was 5 days after Election Day, right? Like counting the ballots, the mail-in ballots, and that the Fifth Circuit had ruled that's unconstitutional, or, that basically federal law, I guess it is, sets one election day. Is that they've taken that to the Supreme Court, right? So like you have the standing one, and then you have this.
I imagine the court is holding that one pending the outcome in Bost, because how they decide here is going to affect a lot of these other kinds of challenges.
Okay.
The state specific rules are obviously all very different, but the Supremes are going to set out a uniform constitutional rule, presumably, about this.
Yeah. Okay. That sort of was one I've been like watching and kind of how does that jive?
And then, Alex, the third bucket is we talked about sex and politics, and now it's going to be executive power, and that's what you talked about, the Trump term, and in so many different ways. So there's the removal of agency heads of so-called independent agencies, the potential to overturn a 90-year-old case called Humphrey's Executor about whether the president has control of the full executive branch, or if these agencies like the Federal Communications Commission, Federal Trade Commission, if they're not in the executive branch under the president's control, then which branch are they in? It's always been an awkward sort of fit. And given where the court's gone, or in some of these short order interim relief emergency docket rulings, it does seem like they're going to overturn Humphrey's Executor, which won't necessarily affect this other case that was just granted this week, as we're talking about the removal of a member of the Federal Reserve, because there the president is trying to remove Lisa Cook for cause, saying, alleging fraud in mortgage applications and things like this. So the court has been hesitant in extending its view of presidential removal authority to the Federal Reserve. So here there might be some other kind of standard.
Yeah, that's what I was kind of wondering. I know you mentioned the interim docket. They've let people stay on the Merit System Protection Board, right? The National Labor Relations Board. And then, is it the Consumer Product Safety Commission, something like that. So does that give us an idea but Lisa Cook, the Federal Reserve, they've kept on, right? So does that kind of give us an idea of maybe where they're going with this?
They signaled in a short order in a case called Wilcox about the National Labor Relations Board. All these alphabet agencies are coming up. But this past spring in Wilcox, they just wrote a few paragraphs saying that Humphrey's executor is sort of on its last legs, but this doesn't affect the Federal Reserve. So that's why clearly the administration is pursuing this removal for cause. They're not arguing that overturning Humphrey's executor would allow necessarily the president to remove Federal Reserve members as well. But this kind of reigning in control of the executive branch has been a theme, both of this administration and where the court has gone in a host of ways of letting go lower officials, not just agency heads, but reductions in force, about budgetary issues and how the government can and can't spend money that's been appropriated with USAID and other agencies. The court has, part of the reason why the administration has been so successful on this interim relief emergency docket is because the Solicitor General has been strategic in which losses in the lower courts he's taken to the Supremes, and clearly this one over control of the executive branch and its enforcement of its own organizational structures and funding is a place where the court is comfortable having the executive win.
Mm-hmm. Well, I feel like every time we start talking about the big cases of the term, it's by January, we do a reshuffle.
We have a whole new others. I mean, look, the ones that we just mentioned here, I think have legs. I think we will still be talking about them in June, unless they go away for some random reason. I can't, unforeseeable reason, but I think they're big issues, they're meaty issues. They're still going to be talked about in those end of term reviews. But you're right that in the next few months, typically cases that they grant through about the middle of January still make it onto still get decided this term by the end of June. So I'm sure there's going to be half a dozen or more that will make it onto those end of term reviews.
Yeah. Well, anything else before I let you go that I missed or that we need to cover? I really appreciate your time. You've been generous.
For any of your listeners that really care about criminal law, the court has been kind of hesitant to take up meaty criminal law and criminal procedure issues. They've been kind of nibbling around the edges. But the Fourth Amendment is making a return for the first time in a decade in a case called Montana versus Case. And there's an exception to the warrant rule where police don't need a warrant if they're pursuing some emergency thing. They're chasing a criminal suspect who goes into some building. They don't need a warrant to go in there. Well, do they need probable cause about the fact that this is an emergency to go in and search a given location? That's the issue here. And I know that criminal law professors are very excited about this because finally they get something substantive rather than kind of nibbling around the edges of sentencing regulations and what have you.
Well, that will be one to watch. I know there's also been some interest. I think there's a death penalty case that has to do with IQ levels too. I know I've seen some buzz about that one. Well, thank you so much, Ilya. I really appreciate your expertise.
Happy to be with you. Take care. Looking forward to going back to school, as it were, on 1 First Street next week.
Yes, absolutely. Thanks. Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.